Joe had a focus on the special issues. He asked questions that came right out of the jury charge, right out of the questions the jury would be asked. Good trial lawyers do this. Joe had a very special technique for doing it. The way I see it is that you have to condition the jurors to think in terms of the questions they ask. And during the trial, you ought to elicit the answers. It eliminates a lot of deliberation. So here's what Joe did. I noticed, and Janet helped me with this, Joe had an extraordinary affinity for hypothetical questions. We were drinking one night, and he told me, I love hypotheticals, they're my favorites. I said, why? And he said, because they let me tell my story. We know that, but he used them in a way that was profound and well beyond just telling his story. I'm going to first just read through this with you, and then we're going to read through it again when I fill in the facts. This is when John McKinley, the chairman of the board of Texaco, is on the stand. And if you read it as it is, it sounds like Joe is arguing McKinley's case for him. Texaco's argument was this: during its entire history, it had never engaged in a hostile takeover, only in friendly negotiations and mergers and acquisitions of companies. Jamail's three hypotheticals capitalized on that theme, basically accepting it as true. And let me give you, especially those of you who are still trying lawsuits, sit down, excuse me, sit down, think about your opponent's argument, regard it as true, and see where it leads you. I have rarely been in a case where someone on the other side didn't deny the undeniable, didn't just want to run away from the worst fact. You've got to embrace the bad facts. You're not going to win many lawsuits. Sir, he asked of McKinley, is it Texaco's policy to interfere with other people's contracts? No, of course not. If that is the case, then would you stop anyone at Texaco from interfering with someone who has a prior agreement with the same party that Texaco is negotiating with? Joe was not perfect. Grammatically, that was a little hard to follow. And what he's asking is, and I went over this with Jeff ahead of time, if that's the case, that you wouldn't interfere with other people's contracts, would you stop anyone at Texaco from interfering with a contract between Pennzoil and Getty Oil? Why, certainly I would. I assume that if evidence came to you that such an agreement was in fact in existence, then would you have the obligation to make some study, some good faith effort to find out if in fact there was or was not an agreement between Getty Oil and Pennzoil? Answer, yes, of course. I would have to. I did that. Well, let's just go home. You know, it's over. I agree with you, sir. That's not what Joe was doing. This came 3 months into the trial. And his cross-examination of McKinley, which Janet drafted, 87 pages that 79 pages we found. And just parenthetically, one of the things that just stunned me about Jamail is he prepared. He was, as Ronnie points it out, he was a neatnik. He didn't want to be unprepared for anything ever. And they went through the cross-examination. They played roles. They would tighten it up. They'd change the questions. This question, which seemingly gives away Pennzoil's case to Texaco, came in context. It was 2.5 months into the trial. By then, the critical documents had been read into the record so many times that you have to think that some of the jurors could recite him by heart. They had learned already that Texaco set up a 3-stage plan to take the contract away from Pennzoil. The first step of the plan was to enter into an agreement with the museum. This they did. The museum agreed to sell. At the same time, on January 5th, that the museum was negotiating with Pennzoil and sending drafts back and forth saying, we're with you. At that same time, the museum's lawyer was agreeing with Texaco to sell the stock. That was step one. Step two, to get the entire company, was to go to Gordon Getty and tell him the museum, without saying the words, that the museum has already agreed to sell. Tough luck. You're going to be a locked out minority. We're going to have 40%, we're going to have 12% of the stock, we Texaco, from the museum, another 40-something% from the public. We're going to have 60% of the company. Your stock is going to be worthless. And they hammered Gordon Getty into breaking his word and agreeing to sell his stock as well. So let's go through it again. Sir, is it Texaco? And by the way, McKinley personally went to Gordon Getty's suite, this is important, to make the offer of $125 a share. Sir, is it Texaco's policy to interfere with other people's contracts, with Pennzoil's contract with Getty Oil? No, of course not. If that is the case, then, would you stop anyone at Texaco from interfering with Pennzoil's contract? Would you quit negotiating on behalf of Texaco with Getty Oil? Why, certainly I would. I assume that if evidence came to you that such an agreement was in fact in existence, remember this was all over the newspapers, this contract between Getty Oil, the agreement in principle between Getty Oil and Pennzoil, all over the papers, Wall Street Journal, New York Times. It was a very, very important transaction. In fact, the largest of its kind to that point. I assume that if evidence came to you that you had such an agreement was in fact in existence, then would you have the obligation to make some study, some good faith effort to find out if in fact there was or was not an agreement between Getty Oil and Pennzoil? Yes, of course, I would have to. I did that. He didn't. At that point, the jury knew that Mr. McKinley had asked the principals of the company, had asked the principal of the Getty Trust, Gordon Getty, and of the museum, the lawyer, Mr. Lipton, are you free to deal? They said yes, and that's all he asked. And he said, I was assured that we could make an offer and they could accept it. But as Joe pointed out, McKinley never asked anything about the board meeting, never asked to see the minutes, never asked about the 15-to-1 vote approving the Pennzoil deal. And over again during this trial, as I'll illustrate in the next slide, John McKinley defaulted to his constant answer. All we knew was there was an agreement in principle that needed to be negotiated. And one of the things that I'm sure that the trial lawyers in this audience know is that when somebody constantly falls back to some defense, juries get real tired of hearing it. You know, you say to the witness, okay, you've said that, I'm going to give that to you, Mr. McKinley. I know you didn't think there was a binding contract, but now answer my question. Ronnie, you might want to take notes on that. Now, here's something that Joe did. Now, let me stop before I go to this. Janet, what you'll find in the book when it comes out, I asked Janet if there was some magic going on with these hypotheticals. And let me back up a minute. One of the things that Joe did, and I'll just give you this is one of the things that I discerned from what Joe did. We know that when we ask hypotheticals, witnesses are coached to say, I won't accept your assumption. If Joe had said to McKinley, would you assume with me that there was a binding agreement between Pennzoil and Getty Oil? McKinley would have said, no, I won't assume anything like that. I'm not going to accept that premise. Joe could have also said, would you assume that there was a binding agreement and Texaco knew about it? And he'd have said the same thing. But what Joe did, and what I think is a very smart thing to do, is he took McKinley's position. He took McKinley's words and used the hypothetical. So when he says, sir, is it Texaco's policy to interfere with other people's contracts? What he was saying was, we're going to use the words you used. Those were his words. Texaco had bragged about their policy. And so on, and it just goes on and on. So one of the things that you should try to do always is to find the truth, find out whatever the other side is saying is at the heart of their case, give them that assumption, but expose the irony of it. That's what made this so strong. Joe's favorite writer was Mark Twain. And if there was ever a master of irony greater than Mark Twain himself, it was Joe.